As a certified specialist in family law, I am often shocked by how confidently people state things about family law in social media posts and comments that are absolutely wrong. There are clearly a lot of serious misconceptions about family law out there, from how property is divided to what being common law means to parenting to support matters. People who have bad information can make bad decisions, so in this episode of the Ontario Family Law Podcast, I will go over some things that ordinary people get wrong about family law. I'm John Schuman, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. I'm just going to start right in with some of the things that ordinary people believe about family law that are absolutely wrong. There is no particular order. Separated spouses divide all their assets 50-50. Married spouses without a marriage contract equalize their net family properties pursuant to Ontario's Family Law Act. The way that works is a long way from dividing assets 50-50. The general rules are that the married spouses should have the same increase in their net worth between the date of marriage and the date of separation, and that usually involves one spouse making a payment to the other spouse. Married spouses do not own each other's stuff. However, there are also some big caveats to that rule. Gifts, inheritance, and personal injury awards to one spouse are not shared unless they are commingled with the other spouse's assets. If the house where both spouses lived on the date of separation is the same one that one or both of them owned on the date of marriage, then the entire equity in the house, not just the part that accumulated during the marriage, is divided. If one spouse's net worth declined during the marriage, then it is deemed to have stayed the same. How much one spouse saved during the marriage can have a big impact on what the other spouse has to pay. Support obligations can offset what one spouse has to pay to the other. It is a much more complicated calculation than just dividing everything 50-50, and the details can make a big difference to what a spouse has to pay. At very least, read more about it in my book, but better yet, speak to a family lawyer about how the calculation works for you. Being common law is the same as being married. Not in Ontario. Cohabitating for 3 years or living together and being the natural, declared, or adoptive parents of a child means that one partner may have to pay the other spouse's support even though they are not married. That's all that being common law means in family law. All parents, married common law or otherwise, have a legal obligation to support their kids. Common law spouses have no right to equalize their net family properties under Ontario's Family Law Act. There is no legal requirement that they divide their property differently because they are living together. There are some other property claims that frequently apply to common law spouses, usually because one has profited at the expense of the other, but those are not claims pursuant to any statute, and they are complicated, so you need to speak to a lawyer if you need to bring them, or defend against one. If you find this information helpful, please hit the like button, as it really helps us with this channel and helps other people find this information. Also remember that this is episode 85 and there's a lot of helpful advice in the other episodes, so please subscribe, hit the notification bell, or get a copy of my book to make sure you get even more helpful information. 12-year-old children get to decide with which parent they want to live. There is nothing in any family law statute that says that. It's not until healthy children turn 18 that a judge can stop making parenting orders. Judges order teenagers to live with one parent, often over the teenager's objection, all the time. Despite what the UN Convention on the Rights of the Child says, many family judges do not even want to hear the children's opinion, either out of concern about forcing the children to take sides, or to prevent the children from being manipulated by their parents, or to fear that they've already been manipulated by their parents. The opinions of older children that are independently formed are about one of many factors that a judge has to consider. Check out the episode on how judges make parenting decisions for an explanation of all of them. Leaving aside the debate about whether the new family law legislation abolishes parental rights in favor of a focus on the interests of children, the children do not have a veto and do not decide where they want to live until they turn 18. On a similar note, the family law legislation does not say that kids should be with their mothers. It does not say that kids should be parented by their fathers, even if they are unfit. It purposely does not set shared parenting as being the starting point. The focus is supposed to be on the children and the children's needs, and which parent is best able to take on the necessary responsibilities of raising them. When I first started practicing, it was true that women were more likely to have stayed home to look after the kids and had become the primary, sometimes only parent because the father was the hard-working breadwinner. That resulted in a situation where moms couldn't work and dads couldn't parent. But the world has changed a lot since then. Women are at least as likely to be professionals as men. Most households have both parents working full-time. It is now culturally normal for fathers to be involved in every aspect of parenting. All the sociological reasons why kids usually ended up with their mothers are now gone. Now judges and arbitrators have to look at what is going on in each family and what parenting arrangements best serve the particular kids. Parents who feel that the family court is biased against them will accomplish more by meeting with a good family lawyer to figure out what they are doing wrong than accusing the court of bias. The internet is full of complaints by people of all genders saying that the court is biased against them, so that just can't be true. It is easy to hide income or assets in family court. This is a bad strategy. It may be true that not all lawyers are equal and some will not catch on to what is going on, or will not ask the right questions or seek the right disclosure. But if the parties end up before a family court judge who hears family law matters one after the other every single day, they have seen and heard every trick being tried. They are not easily fooled and are very suspicious of anyone that doesn't look perfect. When the innocent party hires an experienced family lawyer, not only can that lawyer find the missing money, but the lawyer can make the other side look dishonest, immoral, unreasonable, unlikable, and unsympathetic. In short, a good family law lawyer can not only show the other side is hiding things, but give the judge a list of good reasons to rule against that dishonest spouse. Then the spouse comes off worse, sometimes paying hundreds of thousands or even in some recent cases millions more than the spouse would have had to pay after disclosing everything properly. It's a bad strategy. Avoid being the spouse that hides things. These are some of the most common things that ordinary people get wrong about family court. There are a bunch more. Watch for future episodes, or even better, speak to a good family lawyer to make sure you understand how the law works in your situation. Call us at 416-446-5847. Don't rely on social media comments or the advice of people who are lost in family court. If you need some more general family law or children's law guidance, or you need to understand Ontario family law better so you can make better decisions, if you need to know the best parenting options after separation, or if you need to understand how finances work during a marriage or common law relationship and after separation or divorce, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook store on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. You can also set up an appointment to speak with us by calling 416-446-5847. It is always best to get a lawyer who can give you expert advice that is specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter at @SchumanFamLaw, and finding me on LinkedIn. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions on the Ontario Family Law Podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.